Sure. I know the government tried to fall back on Article 1, saying that basically they had, let's see, that Congress had the broad authority to make laws necessary and proper to carry out its designated responsibilities. And they basically threw that out because they said, you know what, you can decide whatever you wanted to decide.
Right. Well, the court here said that basically the necessary proper clause is really part of the the enumerated powers clause, and it's really, it doesn't add anything that the Commerce Clause, if the Commerce Clause, if it's unconstitutional under the Commerce Clause, it's got to be unconstitutional under the necessary and proper clause. The necessary and proper really doesn't add anything else, and that the Commerce Clause doesn't allow.
So it doesn't give them a broad license to do whatever they want.
Right, and the court,
necessary and proper.
Right, and the court looked at that, and in fact, the court only had about 3 lines about the necessary and proper clause. So it just doesn't add anything else here. They dismissed the government's argument about that. But good question. And the last thing that the court looked at was the plaintiff's request, the state's request for an injunction that not allowing the government to enforce the health care law. And the court denied the request for an injunction. However, the court said that you assume that we make the assumption that the federal government and federal government officials will not enforce an unconstitutional law. So just declaring something to be unconstitutional is, in all practical terms, the equivalent of an injunction. So we don't even need to issue an injunction here. And that is basically, in summary form, the 78-page decision. And any questions?
Yes, I have a question.
Sure.
If the court has said that we make an assumption that when we declare a law unconstitutional, right, that we make an assumption that the executive branch will no longer enforce that law, what happens when the executive branch under Obama decides that it will enforce that law, even though the courts have said its unconstitutional assumption is that they should not enforce it? I mean, doesn't that set up a constitutional crisis?
It can. I mean, well, part of the problem is that you have 2 courts who's saying that it's constitutional. It's saying that the individual mandate is constitutional. You have another court saying it's unconstitutional, but who refused to say that the entire law is unconstitutional. And you have this court saying that the entire law should be disposed of. So what's going to happen? I mean, what's going to happen is it will work its way up to the Supreme Court to resolve all these differences as to the split between the courts.
But if this is the last decision, this is the, I mean, it's not the last, it's the last decision of in the progress of decisions. Should the Obama administration now cease and desist in the processing of this law?
Well, we'd love to see that, but they're parallel. The fact that this law was issued the last in time is doesn't give it more force and effect than the other decisions. All of these decisions were issued by courts at the same level, district courts throughout the country. And our federal court system is a 3-tiered system. You have the district courts, then it goes up to the Court of Appeals and the Supreme Court. So, right now you have a split among the districts. None of the courts of appeals have spoken on it. Presumably there'll be some kind of split between the circuits, and then the Supreme Court will look at it. So that's the response. Any other questions about this or comments? I'd love to read comments.
Are you as excited as you look about it?
Yes, I'm very excited. I don't know if I looked at it. I don't know. No, one of the things I loved about the decision also was I had actually written a piece about the individual. I had actually written some pieces about this, and I had written a piece about well, if this is allowed, why can't the government just pass a law that mandating that people have to buy broccoli? And it was very funny because in this decision, the court actually made the same comparison and said, well, if you can require people to purchase health insurance, why can't you require people to buy broccoli? And I said, I wonder if they read what I wrote. I wonder if they read the little blog I wrote.
Well, you seem very excited about it.
Yeah, no, but I think, no, it's a great decision. It's an amazing decision. And, what it will mean, and, if the decision holds through the, Supreme Court level, is that the Republicans will have the chance to have a real say at the table, finally, about what's in the health care law. You know, and their repeal will be of some value, and you know, there's going to be a real discussion with everybody at the table, and the Democrats can't just ramrod something through like they did, you know, prior to you know, the Republicans taking.
Thank you.
And
could it be null and void before it gets to the Supreme Court?
well, that's what this court is saying, but you know, it's because of the differing decisions. Probably, you know, it's kind of thrown things into disarray.
How long do you think it'll be before it will actually we'll get it from like the Supreme Court? Where, 'cause this administration will just go ahead and do whatever they want to do anyhow, until somebody says, you can't do that. And they'll still argue about that. I mean, it's just, they don't seem to care about anything as far as that goes. How long do you feel it'll be before it hit like Supreme Court, roughly, you know?
I mean, it's at a minimum, it's probably going to be a couple of months to work its way through all the appeals courts, and then a couple of months after that to get to the Supreme Court. That was my guess. I mean, you know, I mean, that you can apply for expedited proceedings and so on. It's really up to the courts to decide this in the various, you know, circuit courts and the Supreme Court as to whether they take the case.
Because if anything, they'll squelch all this movement as fast as they can. So that it could take years before it would get to the place where,
Right.
you know, I mean, they just don't give a damn.
Right. I
Well,
mean,
the White House lawyers are working very hard too,
Yeah.
to like get
Oh,
this
yeah.
verdict set aside and.
Right. I mean, the court commented that the briefs were really excellent, and also there were all these amicus briefs, you know, by, you know, different interest groups, pro and con, filed in this case. You know, it's been, you know, it's very well litigated, a very well litigated case.
Now, until they reach a final judgment, a lot of this stuff is already starting to be implemented.
Right.
Can they do that now? If the whole thing, because
Sure.
now everybody's
They will.
gearing up to all of these different things, and if they find that, you know, it's null and void, then they have to go backwards and undo a lot of stuff.
Mm-hmm.
So, it's like you're leaving the employers and everybody else in limbo right now.
Right.
Yeah.
Well, that's one reason why, you know, that's one of the issues that I'm sure, you know, plaintiffs and everybody will be bringing to the attention of the courts, you know, that there's a need to act expeditiously,
Right.
and, you know, taking these cases and reaching decisions. People, you know, that's definitely, you know, a problem.
So does it just depend on how the deck is stacked, so to speak, in the courts?
You know, I don't, you know, it's interesting. I mean, you know, I guess like that gets into the whole issue about whether, you know, Republican-appointed judges always decide cases in favor of, you know, whatever the Republican decision is, and right, you know, the Democratic judges do the same thing. And I don't know that, I mean, my experience as an attorney is that it doesn't always follow that, I mean, the judge who issued this decision was a Reagan appointee, Republican appointee, and now all the Democrats are all just, you know, saying, oh, well, you know, it's just, you know, he's an activist Republican judge. We should
Look at
disregard
Earl Warren. He was a Republican appointee, and certainly
Yes.
the Warren Court was.
Mhm. That's right, and you know, my experience as an attorney in various cases that have, you know, political ramifications has been that you don't know. I mean, if you have an honest judge and, you know, who tries hard to see the issues and to just look at the constitutionality of something, you know, even if they are appointed by, you know, what you would think was the other side, a lot of times they'll come out with, you know, a decision the right way. You know, so you know, I don't necessarily. You know, sometimes it's true that, you know, Democratic judge will just make sure to decide a case in, you know, in a political way, but, you know, hopefully we have judges who are honest and will, you know, and we do. I mean, it's a mix. So sure. I mean, just like, you know, the Supreme Court often breaks down along party lines, but there are always these cases where people surprise you and, you know, they come out one way or another and, you know, that you wouldn't expect. So.
Yeah. These cases where Justice Kennedy surprises you.
Other comments? Anyway, this is great development, and you know, one of the things that's very exciting about it also is that initially, when attorneys general first began to bring these cases, you know, Democrats poo-pooed it. Oh, this is a far-out view. But now that a court has issued this very well-reasoned decision, it shows that you know, this law is unconstitutional. Really has force. It is, you know, And I've been saying all along that it's unconstitutional, a lot of people have, but it really means something to have a decision like this on the books. It's a great step, great victory.
Now, how is this decision different from the first decision?
Well, I mean, the earlier decisions were held that the law was constitutional.
That was in
Isn't it
Michigan,
two and
but
two
what
now?
about
Michigan and the
Virginia?
Michigan and the Western District of Virginia held that it was constitutional. Eastern District of Virginia said it was unconstitutional. So,
On the mandate, it was based on the.
based on the mandate. Nobody has held in favor of. Nobody has said that the Medicaid mandate is unconstitutional. So it looks like that's going to be a loser.
A point of fact, this was the district court,
Right,
so it'll go to the circuit court and then it'll go to the Supreme Court.
right. So it's great decision. The other. Anyway, any other thoughts? Anyway.
Thank you very much, Lynn.
Thank you.